All right, the other big story we're watching for you is unfolding now at the Roodepoort Magistrate's Court. That's where the bail hearing for Tiffany Meek has just started. She's the woman, of course, in the dock for the murder of her own son, Jayden-Lee. She's just broken down, in fact. Let's take you there live.
To report the deceased SABC. A docket was registered Florida Press 0205-2025. On the 14th of May 2025, the deceased was then discovered by the security guard in the passage few meters outside his residential unit, and the deceased was declared dead on the arrival of the Discovery Community Health Center. Upon a search at the time of the accused residential place on the 14th of May 2025, the child's bed had blood on it. The deceased school clothing and the bag were found in the accused's house or unit, with one of the school books having blood. Forensic analysts confirmed that the blood was the deceased, and various other evidence confirmed that the deceased was harmed in the house. Now therefore, the accused is guilty as charged as set out hereinafter. Count 1, murder, read with the provision of section 51, subsection 1 of the Criminal Law Amendment Act 105 of 1997, as amended by section 15 of the Criminal and Related Matters Amended Act 12 of 2001. In that, upon or about the 30th of May 2025 at Oria, Playhoff in the Regional Division of Gauteng, the accused is unlawfully and intentionally killed Jayden-Lee Meek by hitting or striking him with an unknown object. As a result, the deceased died as a blind force head injury. A regional court or high court shall sentence a person which has convicted of the offence related to Part 1 of Schedule 2 to imprisonment for a life. Murder when a person is under the age of 18 years. Count 2, defeating or obstructing the administration of justice. In that upon or about the 13th day of May 2025 at Onia, Florida, in the Regional Division of Gauteng, the accused wrongfully and intentionally performed the following act. She reported now the deceased child, Jayden-Lee Meek, as missing, in not having returned home from school, and whereas the accused, when she acted as aforesaid, well knew and intended that her action would have the following results or consequences. She would not be the suspect and her premises will not be searched. And whereas as a result of the action of the accused, other person were suspect and cause other person premises were searched, and though the accused defeated or obstructing the administration of justice. Preamble to count number 3, whereas the deceased, being a scholar, using a transport as set in the general preamble, he was transported by Mr. Khumalo driving to a Volkswagen bus. The deceased was picked up at the gate of the complex, his residential, in the morning, and dropped off again in the afternoon at the same gate by Mr. Khumalo. On the 13th of May 2025, the same process was followed without no changes and no reason to change. Count 3, crime injury. In that, on or about the 13th of May 2025 at Onia, Playhoff, in the district of Gauteng, the accused did unlawfully and intentionally injure or insulted or impact the dignity of Mr. Ndongwane Khumalo by accusing him of the child's disappearance or not having returned the child from being the last person that was with the child, and causing Mr. Khumalo to be considered a suspect and having his house searched by the police looking for the deceased. Count number 4, attempting or defeating or obstructing the course of justice, in that upon or about the 14th day of May 2025 at Onia, Swazi-Vliehof in the Regional Division of Gauteng. The accused did unlawfully and with intent to defeat or obstructing the course of justice commit an act to with placing the deceased or putting the deceased in the passage outside her unit to lead the conclusion that the deceased was harmed somewhere else, or whoever harmed him placed him in the passage between the unit where he was discovered by the security guard, which attempt or defeat or obstruct the administration of justice. Worship, those are the charges against the accused person, and this is a Schedule 5 bail application, and the state is opposing the bail application. To the court, please. Bishop? Not 6. No, it's not 6, Bishop. It's a Schedule 5, Bishop.
It's murder of a child.
Yes, it's a murder of a child, Bishop.
Exactly what is the court? Yes, whilst we wait for the law.
These are the applications because they on the page.
Can the court place on record before we commence with these proceedings any further that there has been various applications made by various media houses which are present here in court today. The court also placed on record that present in my chambers was Mr. Naidu. Present in the chambers was the State Prosecutor, Ms. Chauke, where these applications have been canvassed, and the court then issued a draft order. The draft order is marked X for the record, which fully sets out the conditions of the order that the various media houses is to comply with. Mr. Naidu, for the record, can you confirm that that's indeed what transpired in chambers?
Your Worship, I confirm my appearance on behalf of the accused. I confirm that that was the arrangement as per the court's order in chambers. The defense has no objection to the court order.
Thank you. The draft is therefore marked X for the record.
Please do not. Can I sit next to your colleague and explain Bishop 5 or 6, because I'm going to explain the rights now.
Ms. Meek, you may have a seat. Mr. Naidu, whilst we wait for the state, I will not have any objection if you want to have a word with your client in the meantime. Is it fine? Yes, that's fine, thank you.
All right, it's just about 13 minutes towards 11 o'clock, and we're listening to the bail application of Tiffany Meek, the woman in the dock there on the main side of your screen,
from the research
after her arrest in relation with her child's murder. Let's continue listening in.
Of the Criminal and Related Matters Act number 12 of 2021, the sentence has been amended. So the murder of a person under the age of 18 now attracts life imprisonment, the same as when it's pre-planned or premeditated, and when it's robbery with other offenses and so on. But then when it comes to the schedule, Worship, they amended everything else except that schedule. So even though the minimum sentence is life imprisonment, but the schedule hasn't changed. So in this case, Your Worship, it is Schedule 5 because we cannot we'll be hard pressed to allege pre-planning or premeditation and so on.
And that's what we are proceeding on.
As a court pleases.
Ma'am, the state submits that the offences you are charged with results under Schedule 5. What that means is that the court shall order that you be detained in custody until you are dealt with in accordance with the law, unless, having been given a reasonable opportunity to do so, you adduce evidence to satisfy the court that the interest of justice permits your release from detention. Do you understand? The court further explains to you the provisions of Section 6011 capital B subsections A, B, C and D, which provides in bail proceedings you are compelled to inform this court of all your previous convictions, pending cases and outstanding warrants. If you willfully mislead the court by providing false information, the court may upon conviction fine you to 40,000 rand or 2 years in jail. Do you understand? The court further explains to you that the record of these bail proceedings, excluding the information in paragraph A, shall form part of the record of the trial of the accused following upon such bail proceedings, provided that if the accused elects to testify during the course of the bail proceedings, the court must inform her of the fact that anything she say may be used against her at her trial, and such evidence becomes admissible in any subsequent proceedings. Do you understand? Please have a seat. Mr. Naidu.
Thank you, Your Worship. I confirm, Your Worship, that as per the state's schedule, it is a Schedule 5 bail application, Your Worship. The defense is in a position to proceed. We've prepared an affidavit, and the accused will be testifying by way of affidavit, Your Worship. Thank you, as the court pleases.
Thank you.
In the Magistrate Court for the Regional District of Johannesburg West, held at Roodepoort, case number SH233/2025, in the matter of the state and Tiffany Meek, the accused and applicant. This is an affidavit in support of bail. I, the undersigned, Tiffany Meek, do hereby make oath and state as follows. I am an adult female with identity number 940112-0342-085. Prior to my arrest, I was residing at my mother's place of residence, being Flat 5, San Lida, 8 Ivan Street, Roodepoort. I have been residing at this address for the past 2 months since the passing of my son, Jayden-Lee. At the time of my son's death, we were both residing together at Unit 13 Swazi Place, the corner of Lily and Daffodil Street in Vleerhof, for approximately 2.5 months. The facts and circumstances deposed to this affidavit are, unless otherwise indicated, within my personal knowledge and belief, and are both true and correct. Where I make submissions of a legal and technical nature, I do so on the advice of my legal representatives. This is an application for my immediate release on bail, pending the finalization of my trial, whether in the regional court or any other forum as the case may be held. I am charged with the following offences: Count 1, murder; Count 2, defeating or obstructing the administration of justice; Count 3, criminal injuria; and Count 4, attempting to defeat or obstruct the course of justice as per the charge sheet. I do confirm that these charges have been explained to me by my attorney and is listed under Schedule 5 of the bail legislation as contained in the Criminal Procedure Act 51 of 1977. The purpose of this affidavit is to provide the above Honourable Court with my personal circumstances and to address allegations levelled against me, insofar as they are known to me, as well as to address the factors to be considered by the above Honourable Court, which are contained in Section 60, subsection 4 to Section 60, subsection 9 of Act 51 of 1977. The background to this application. I was arrested on the 11th of July 2025 at my mother's home on the suspicion of having committed the offences as set out in Annexure A of the charge sheet. I add that I have been incarcerated since the 11th of July 2025 for a period of approximately 8 days. After my arrest, I was detained in custody at Roodepoort SAPS, and after my first appearance in court, I was detained at Johannesburg Sun City Prison. At my defense, I have been advised that I bear the onus and burden to show that the interests of justice permit my release on bail. I fail to understand how I could be charged with the murder of my son when I was the person fighting for answers from the police and doing everything possible to ensure that my child's killer and or killers were found and arrested. I will attempt to place factors before this honourable court to show that it is in the interest of justice to permit my release on bail. I record that I will plead not guilty to the charges and put the state to the proof of every averment. I am not able to disclose the basis of my defense, as I have not been advised as to what evidence the state has against me, and neither have I been given a copy of the docket. I reserve the right to reply to any allegation made by the state which is not covered in this affidavit. At this stage, I deny any wrongdoing and any involvement in any of the offences contained in the charge sheet. However, I wish to bring the following to the attention of the above honourable court. Jayden is normally dropped off from school by his school transport between 3 and 4 p.m. On the 13th of May 2025, he had failed to return home by 4 p.m., which was the time I stopped working. At that time, I was chatting to my mother and informed her of his non-return, and due to not having airtime, I asked her to contact the transport owner and driver to ascertain if Jayden was dropped off and if there was an accident or delay. My mother contacted the transporter, and a while later she was informed that Jayden was dropped off around 14:45. I started to panic and look for him around the complex. It was getting closer to 5 p.m. and he had still not returned and could not be seen in the common area. I then approached the day shift guard, and he informed me that he could not recall if Jayden entered the complex. The night shift guard who lives on the premises confirmed that he saw Jayden enter the complex and he did not exit. We also confirmed with the child who was dropped off after Jayden, and he confirmed that Jayden entered the complex. My mother sent her friend to collect me around 7 p.m. with a motor vehicle, and we all went to Florida SAPS to report Jayden as missing. I was asked to complete a missing persons report, but it could not be lodged as the police needed to wait 24 to 48 hours, and they also wanted a printed copy of his photograph before opening a docket. 2 police officers came back to Swazi Place with us, but refused to go door to door and search for Jayden. We met 4 other officers on the way, and a total of 6 officers came back with us to Swazi Place. They first told us that it was too late to disturb the neighbors, that it was around 9 o'clock that evening, and thereafter told us that they don't have a search warrant. My brother Q and Dunn then went to a few units and knocked their doors, but was threatened with arrest and had to stop. On the 14th of May 2025, at approximately 06:50 that morning, I received a call from Laracho, the transporter, who informed me that Jayden had been found at Swazi Place. My sister Simone and her husband took us over immediately. It should be noted that Jayden was found around 6 a.m., yet we were only contacted at approximately 06:50. No one bothered to call the ambulance or police or even rush my child to hospital, as he could have still been alive prior to our arrival. We took Jayden to Discovery Hospital in our vehicle, but he was pronounced dead on arrival. My son could have still been alive if he was taken immediately for medical attention or if an ambulance had responded. The following is an approximate timeline of the police's handling of this matter and the events leading up to my arrest. The police refused to assist us on the night of the 13th of May 2025 and kept telling us that Jayden is probably with friends or got lost coming home. We were asked to drive around the neighborhood and look for him, which we did, and also had the help of the CPF and a security company. My mother asked me to stay by her as she lived closer to Florida SAPS, and if Jayden was found by the people searching for him, we could make our way to the station. The CPF and our family members continued to search on the night of the 13th of May 2025. I was devastated and emotional, and my mother and sister waited with me at my mother's place for any news. After Jayden was pronounced dead at the Discovery Hospital, we waited until the forensics and pathologists arrived, and we went back to Swazi Place. The first group of police arrived at around 9 a.m. to conduct investigations on the 14th of May 2025 at Swazi Place. At approximately 10 a.m. on the same day, my sister Simone opened my flat and allowed the police in. They searched my flat, and a member of the Hawks Division was also present with members from Florida SAPS. It should be noted that Jayden's school bag and school uniform was not found inside my flat on the 14th of May 2025. The photographer arrived at 1300 hours and took photographs inside my flat. The sniffer dogs followed Jayden's scent to the flat where the security guard was living, but the police refused to enter this flat. And we were once again informed that the police had no search warrant and could not enter the guard's flat. The members of our family, community activists, friends, and members of the community were in and out of my flat on the 14th and 15th of May 2025. On the 16th of May 2025, we were contacted by the police and informed that they were unable to gather forensics and evidence on the 14th of May 2025 and wanted access to the flat. The photographer was also present for the second time, and this was when the entire case took a turn and I started to get framed for Jayden's murder. I was informed that his school bag, uniform, blood-stained underwear and bed sheets with his blood were found on the 16th of May 2025. It is highly improbable and impossible for the police to have not seen or found these items as alleged on the 14th of May 2025. Further, I am confident that the moment that Jayden's blood-soaked clothes and school bag was found, I would have been arrested immediately and not almost 2 months later by the police. I was even informed that Jayden's blood-soaked underwear was found in the bathtub on the 16th of May 2025. This is impossible, as we had so many people use the bathroom on the 14th and 15th of May 2025. Someone would have most definitely saw the underwear in the tub and alerted the police. Personal circumstances. I am 31 years of age and I am married, yet I am separated from my husband since 2022. I was the mother of 2 children, both of whom have passed away. I was 18 years old when my first child was born and passed away 2 days after birth. I was the sole breadwinner for my son Jayden-Lee and I. Since his death, I have been living with my mother and brother, and I provide financially for my family. I support my mother and brother. My net monthly income is an amount of approximately 17,500 rands. This money is utilized to support my family financially and to meet all our expenses. Inter alia, expenses of the household, food, clothing, transportation costs, and other various personal expenses. Kindly find and enclose my confirmation employment letter marked Annexure A. Your Worship, the legal court, may I have leave to read out the annexures for the record purposes? As the court pleases. Annexure A. A letter from the Jumpstart Foundation, dated the 14th of July 2025. To whom it may concern. Regarding the confirmation of employment, Tiffany Meek. This letter confirms that the Jumpstart Foundation has employed Ms. Meek since 9 October 2023. She initially joined the organization as an administrator and was subsequently promoted to the role of internal project coordinator in April 2024. As of April 2025, Ms. Meek holds the position of executive assistant. She remains employed by the Jumpstart Foundation and serves as a critical resource to the senior management team. Her role spans all divisions of the organization, a responsibility she continues to fulfill with dedication. Please feel free to contact me directly. It is steve@jumpstart.org.za should you require any further information. The statement has been signed by Mr. Steve Mahoney. My character reference letter is marked Annexure B. This is also a letter from the Jumpstart Foundation, Your Worship. It reads, to whom it may concern. Professional reference for Tiffany Meek. To whom it may concern. This letter serves as a reference for the workplace conduct of Ms. Tiffany Meek, who has been employed under my supervision for just under 2 years and is currently serving in the role of executive assistant. Throughout this period, Ms. Meek has demonstrated professional behavior in the execution of her duties. She constantly conducts herself with diligence, maintains confidentiality where required, and communicates appropriately with colleagues and stakeholders. Her conduct has remained within the expectations of a professional working environment. This reference is limited to her conduct within the workplace and does not extend beyond the scope of her professional responsibilities. Your Worship, Annexure C is the payslip, and my payslip is marked Annexure C. Your Worship, it's a payslip confirming the accused net salary of approximately 17,500 rands per month. May I continue, Your Worship? As the court pleases. I have an alternate address being 62 Havenwood Road, Trennans Park, Verulam, Durban. To my father, I have been informed that the investigating officer has already confirmed this address. I submit that if I am released on bail and allowed to resume my employment, Your Worship, I beg the court's indulgence. I submit that if I am not released on bail and allowed to resume my employment, my family and I would suffer financially. We are an extremely close-knit family and we are not well-to-do. My salary contributes to part of my mother's monthly expenses, our food, transportation costs, and my personal expenses. My family and I would suffer emotionally, financially, and mentally if I am not released. I have lived in the Gauteng area in excess of 17 years, and I am well known by the community at large and within the area where I work and reside. I will be able to raise some money with the assistance of my family for the purpose of paying bail. I am able to afford an amount of 5,000 rands for bail. However, I will leave the amount of bail to be decided by this honorable court. I, however, respectfully submit that my personal circumstances and the factors mentioned herein above illustrate that there is no likelihood that if I was released on bail, I would attempt to evade my trial. I do not have the means nor the support to flee this country, hence I am not a flight risk. I would like to record at this early stage that if the state persists with the charges against me, I wish to stand my trial and that I want to explain insofar as I can, and also will lead evidence if necessary that I am not guilty of any offense. I am still in shock and coming to terms with these allegations and charges, as I have been the person asking for proper investigations into the death of my child and verily believe that the police have failed in its duties to properly investigate this matter. My family and I will now have to attempt to engage the services of a private investigation company, as we have no faith in the investigation team from Florida SAPS. I will now, on the advice of my legal representatives, deal with what I am informed are the various factors to go with the proper assessment of the application herein, which would illustrate that there are exceptional circumstances present which would, in the interest of justice, permit my release. The factors illustrating that if I am released on bail, I would not endanger the safety of the public as envisaged by Section 60, subsection 4, subsection A, read with Section 60, subsection 5 of Act 51 of 1977. I respectfully submit that if regard is had to the factors mentioned in Section 60, subsection 4 and 5, which has been explained to me, that the following ought to be taken into account, namely, although I admit that the allegations herein pertain to what is regarded as serious crimes, they have been seen in the light of all the circumstances, and in particular to the fact that the evidence linking me to the incidents is circumstantial at best. I respectfully submit that I do not have any disposition to commit any violent crimes. I am a first offender before this honorable court, and my clean record shows that I have no tendencies to commit any offences, and in particular offences mentioned in Schedule 1 of the Criminal Procedure Act, the contents of which have been explained to me. Whether there is a likelihood that I would attempt to evade my trial as envisaged in Section 60, subsection 4, subsection B, read with Section 60, subsection 6 of the Act. I would now deal with the factors necessary to consider whether the ground of subsection 4B of Section 60 has been established. I am informed and believe that the court would have to take into account the following factors, namely, all my emotional, family, religious, community, and occupational ties are in the Gauteng province, and have been so for many years. My father resides in KZN, and I will live with him if this honorable court decides that it is in my best interest to relocate to KZN. All of my family and financial roots are therefore firmly entrenched in the area of jurisdiction of this court and of Randburg, where I am gainfully employed. I am able to continue working remotely from KZN and will not be required to report to the office daily. I do not have a passport which may enable me to leave the country. I undertake to not obtain and or apply for a passport for traveling without the permission of the investigating officer or the public prosecutor pending the finalization of this trial. I mentioned that I cannot afford to forfeit any amount of bail which may be set, as I live on a month-to-month basis and value every cent.
Does the court please worship the state so that we can have a highlight of the things that were written to the affidavit with the investigating officer? We will request a short adjournment, Worship.
Thank you.
As the court pleases.
Please adjourn for tea. All right, after tea.
All right, so there you have it. Live visuals there that we've been beaming to you from inside the Roodepoort Magistrate's Court for the better part of half an hour or so, where we've just listened to the affidavit submitted by Tiffany Meek, the 31-year-old currently in the dock in relation to her child's killing. 11-year-old Jayden-Lee Meek's body found on the staircase leading to their home a couple of days ago. She's really struggled to keep a dry eye whilst in the dock, breaking down several times. So insofar as the optics are concerned, you have the visual, if you like, or the image of a woman who is distraught. And I suppose that kind of correlates with what she said as part of her affidavit as she tries to get bail. She's emphatically denied that she's been part of Jayden-Lee's killing. She says she's shocked to be the one in the dock in relation with this crime, and she's in fact facing a number of charges, including that of murder, defeating the ends of justice, and criminal injuria. She's already told the court that she's planning to plead not guilty, adding that she's not afraid to go on trial, supposedly to argue her case. Part of the reasons why she has argued for bail or asked for bail is that she is the sole breadwinner, supporting both her mother and her brother. She says they'll suffer if she is incarcerated whilst this trial continues. She says that she will also plans to appoint a private investigator because she no longer trusts the investigators provided by the state to get to the bottom of this case. She's chosen an address outside of the province at her dad's home, she says, in KwaZulu-Natal, because she doesn't want to be seen as potentially interfering with this case if she were to be released. This is also quite important. She says, I don't believe my release will be or cause any shock in any community. And you juxtapose that, of course, with the absolute outrage from the Vleerhof community, with many people, of course, being completely angered by the fact that it is Tiffany ultimately who is in the dock, feeling betrayed, if you like, because the 31-year-old did join them in looking for this child when the 11-year-old was reported missing. Tiffany saying that, in fact, the people who are now turning against her from that community are doing so for their own personal interests. I'll end off with this particular note. She says the state is trying to make this case out to be like that of Jocelyn Smith. Jocelyn, of course, is the 6-year-old, at least at the time of her being reported missing, from Saldanha Bay, whose mother has now been convicted in relation with her disappearance. Kaylee Smith and 2 others being found guilty of kidnapping, amongst several other offences in relation to the child's disappearance. So the state has asked for a bit of an adjournment insofar as this particular case is concerned in order to peruse this affidavit. I imagine they're going to respond with their own kind of statement on the other side of that adjournment.